Hello there and welcome. This is the Disability Law Show. Go figure. I said it right there. John Scholes here. Always joining me, Tamar Agopian, courtesy Samfiru, Tumarkin, LLP. Anytime I want to reach out to Tamar to discuss your disability laws and rights and dealing with an insurance company, possibly an adjuster, maybe a denial. There's a million different things can happen. They're all confusing. They will all cause you strife. But there is an answer. Make that phone call to Tamar and her team. Have that conversation. And that number, anytime, 1-855-821-5900. help@disabilityrights.ca is the email address. I'll give you some more contact information throughout the show. The main topic is going to be 3 fast facts about cancer and LTD. We'll get to that here in just a little bit, Tamar, but we always start off with a case of the day, something you wanted to bring up. What do you think?
Success story of the week.
Love it.
We had an individual who contacted me, I would say about 6 months ago, with his disability claim. He had a couple of health issues happening at the same time, primarily Crohn's disease. He was a sales guy for a large telecom company, and he actually was working through with this Crohn's disease for a number of years before it got to a point where, in fact, a bunch of symptoms came up. He was investigated further. Turned out he had a bone infection. One thing led to another, really, really significant stuff. And in the midst of all of that, had pursued disability benefits. And as disability insurers do, they paid him for a little while and then found an opportunity to deny his claim. But here's what the interesting piece of his situation, and I am going somewhere with this, is he actually was denied both for own occupation and any occupation at the same time. So he gets a denial letter issued basically 3 months before the change of definition. And for our viewers, this is the time where insurance companies get a little antsy and they want to close out that claim. And so they explained to my client that he was either well enough to go back to this very complicated, difficult job that he was doing, upon which they had approved and paid him for something like 20 months of benefits, or worst case, by that point, you should be able to do something else. So either way, we're going to prepay you for 3 months, and then we're going to cut off your claim. So we get involved, we get retained. I start the legal claim. The very next phone call that I get is a call that says, we screwed up here. We're actually going to put him back on claim. And they reinstated my client. Now, it is a success story. My client is very happy. He tried to go through the rigmarole of an appeal. He did. And at the end of the day, he was so happy that our involvement had such immediate effect. Now, I have a couple of theories about this. The first thing is, of course, I think it had a lot to do with who we are, our firm. They saw who was involved, and they thought they are going to put us through the ringer on this file. So best we try and reduce our risk and put this individual back on claim. So I think that was one element of it for sure. And the other part of it, I think, John, is that, he's relatively young. He's 50. There's still another 15 years potentially of disability benefits available to him. And he had a series of health issues that were still being investigated at the time where they cut off their claim. So they hadn't done a proper medical update. They hadn't done a transferable skills analysis to at least look at what else could he do. And that is tied to the any occupation test. In order to get disability benefits approved past your change of definition, the onus is actually on the insurance company to show that there's something else that you can do, both given your health issues that may still be there, restrictions and limitations, and by looking at what your education, training, and experience are. They've got to put all of that together before they can justify that, no, we think you're good to go and you're able to do some other job. Now, the threshold of earnings is lower, absolutely, for the any occupation test. We talk about commensurate earnings.
Yes.
And so usually that's 2/3 of what you're making. So let's just assume it's your LTD benefit. But for my client, he was earning quite a lot in his sales position. His LTD benefit was quite high. And so that commensurate was also high. So the fact that the insurance company didn't do any of that analysis before they cut him off, they knew they were not on good footing. So they had the adjuster who actually reached out to communicate the reinstatement was something like a dispute minimizer, dispute resolution type adjuster. So now these insurance companies actually have individuals who are working at their companies who look at the legal claim, look at the lawyers involved and say, you know what, we're going to do better if we put this individual back on claim and do what we should have done, 6 months ago or a year ago by the time these individuals come to us for help. So word to the wise, if this sounds familiar, if you're in a situation where you've been cut off and it's staggering and you don't understand what's going on, we are only a phone call away. Our consultations are absolutely free. It is not usual to have our clients be reinstated, but I can tell you that when it happens, super rewarding. It's a success story, and certainly one that's really put my client at ease.
Well, I mean, a couple things. The first thing is, you mentioned the firm, and this by no means is a 30-minute advertisement for the firm. It never has been. It's about knowledge and education. But, you're not beating your chest, but it's true. You've said often when you've worked on the other side, when you worked for insurance companies, you get a claim. First thing you do is, okay, who's the representation? It's like, okay, they're a joke, or okay, we got to play ball with this representation. And you're in that situation. So that's good. That's a positive thing for people to reach out to you. Right?
It is. And I think that this is why you want to be careful with what kind of representation that you get.
Yeah.
And I think that I frankly feel better if people are just listening to the show and getting information. And if they need us, great. We're not going to impose ourselves on anyone by any means. But these success stories are success stories for a reason, John. And yes, it's because we've got a great team behind us. We can stay on top of the case law. We understand how disability litigation works. And we leverage that to get excellent results for our clients. And I think that the reputational aspect of the representation that a claimant can get in disability litigation is huge. Yeah. That in and of itself is leverage to get a successful result for you. And you want to be sure that you understand who you're getting involved with. And I can assure you that the insurance companies know who we are and how we operate. And this is why we often get such great results for our clients.
I want to mention a website as well called pocketemploymentlawyer.ca. It's featured regularly and heavily on the Employment Law Show that we do every week as well. But there's a section built into that website, and Tamar's going to explain why. That has to do with disability law. So again, you should go there anytime you want to investigate that, pocketemploymentlawyer.ca. Tell me about it, why you like it so much.
So I like it a lot because it fits within why we do the types of things that we do, John. Our websites, our free consultations, our television and radio. It is free information. And Pocket Employment Lawyer is anonymous as well. So you can put in information about your disability claim and just get a quick response with a couple of pieces of information on whether or not you may have a basis for a disability claim, a legal claim that is. And then it's up to the individual to make the decision whether or not they then want to move forward and actually set up a consult and actually speak with us. But if they don't and they're sheepish about it or they're just curious, totally fine. You close out that browser and you're done. And I got to give Lior his due. This was his conception. He created it really initially for the severance side of our practice, but it's become so critical for disability as well because I think that, with most people, this is the first time they've dealt with disability claims, first time they've dealt with an adjuster or a claims examiner, and they are looking for knowledge and information to maybe level that playing field a little bit,
Absolutely.
Right? Because you've got this big bad insurance company that you're dealing with. You have no idea how to navigate. Right? It is overwhelming. And so tools like Pocket Employment Lawyer, to me, really offer that anonymity and a little bit of that leg up for individuals to have the right guidance in terms of which way to go with their disability claim.
We still have some time to grab an email here before we break. Anytime you want to send one along to Tamar and her team, no problem. help@disabilityrights.ca. All right, this one's going to be Elise. First off, Tamar says, I've been on long-term disability for over a year. I noticed in the past couple of weeks, someone is following me with a camera while I do errands. I'm worried that the insurance company is going to use this against me. Should I change my habits because of the possible surveillance? My doctors have encouraged me to try to find a routine to improve my mental health.
So, the long and short of it is for Elise that I really don't want to see her changing her routines if those routines have been medically endorsed, okay?
Right.
Look, insurers have, or adjusters have, a variety of tools at their disposal when they're adjudicating or dealing with disability claims. Those tools will include surveillance on occasion. It's not in every instance, and I certainly don't see it on every claim. But where you've got potentially symptoms that are inherently subjective, and I think Elise suggests to us perhaps it's a mental health disability that she's struggling with, then there could be a tendency for adjusters to do this kind of surveillance. But they do it because they want to put some money towards the file to then try and fast track to actually bring that file to a close. Insurance adjusters are very cynical, John, unfortunately, and they come at these disability claims assuming that everyone is being not forthright with a disability insurer. And nothing could be further from the truth. The vast majority of people that I speak with would much prefer to be healthy and working and earning 100% of their salary, as opposed to being in a situation where they're struggling with their health and having to deal with these kinds of tricks of the trade, so to speak, by insurance adjusters. Now, Elise can't be sure that she's actually being followed by the insurance company either. So I always worry about safety with individuals as well, is that you can never really be sure if someone is being followed by the insurance adjuster. But most certainly, if you're not doing anything that's offside from what your doctors have told you you should be doing, and it's generally innocuous, as in harmless, then I don't see any reason whatsoever that she should be concerned, even if it is the insurance company that's following her. Because I can assure you, if they make observations, they, as part of their duty of good faith, have to be transparent and forthright with Elise if they're going to rely on this surveillance to bring her claim to a close. So, long and short of it is, I think that she should be okay.
The interesting part of this thing at the end, and you mentioned, is the mental health side of it. This still sticks in the craw of disability insurers. They like to deny it because it doesn't come up necessarily on an X-ray or an MRI. So it's like, are you really sick? Should you really be off? You fight this all the time, right?
We do, and I think what's troubling with mental health claim is that it doesn't actually align with surveillance. The conception of surveillance is really one where you want to try, I suppose, to catch someone doing something that's completely at odds with their disability. Mental health doesn't fit into that neat box for adjusters, right? What are they going to observe you doing? Perhaps you have over-medicated yourself so that you can go to the grocery store and get the food that you need. Or you're going to put yourself into that setting regardless of your mental health conditions so that you can eat, right? I'm just giving an extreme example, John, because that, to me, doesn't tell me much about the disability claimant, nor is it necessarily all that much far at odds from what would be typical in terms of day-to-day activity. I think that insurance companies and adjusters really rely far too much on these observations to suggest that there's something untoward going on, when really the vast majority of the time it's a no-never-mind situation, and courts have recognized that as well. So I want to try and put Elise's mind at ease, and perhaps others who may be listening and thinking, oh, you know, maybe I've got an adjuster who's going to try and do some surveillance. If you're being forthright with the adjuster and your doctors, let them do it. And if they cut you off for any reason whatsoever, and including the surveillance, you know we're only a phone call away.
And with that, we'll take a short break. 3 fast facts about cancer and its relationship to long-term disability is coming up on the other side. Here's our number to reach out to Tamar and her team. Of course, 1-855-821-5900. Email help@disabilityrights.ca. We'll continue more of the Disability Law Show is just ahead. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you so much for hanging through the break here, the Disability Law Show. I want to remind you, you can reach out to Tamar and her team anytime. No problem. Phone call 1-855-821-5900. Email, if you choose, is help@disabilityrights.ca. Topic: 3 fast facts about cancer and LTD. Number 1 is this. Tomorrow we'll get into this. Individuals diagnosed with cancer who have been able to work for a period are still able to apply for LTD with the support of their doctor. Yeah.
Absolutely. This is a fact that's important, because what tends to happen, at least from my limited experience with those with cancer, and look, different types of cancer, John, so we're going to try and talk about this more generally. But you get a diagnosis for cancer, and then there's a treatment plan that's put in place afterwards. And that treatment plan can include surgery. It can include chemotherapy. It can include radiation.
Yeah.
It can include medication. There's a whole host of things that go into treating someone who has cancer. And so you can see how perhaps you have the diagnosis, you continue to work, and until that treatment plan is put in place for you, perhaps the symptoms that would then render you disabled come at a later point following the diagnosis. So do not be discouraged if the insurance company has said, well, but you were diagnosed and then you applied later. It doesn't necessarily mean that the two go together. The focus really for you and your doctor should be that if those symptoms are at a point where they are rendering you unable to work, and at the initial phases it'll be whatever job you're doing at that time, then that is the point in time to initiate the disability claim. And it can be starting with short-term and then going into long-term, but it is absolutely a valid disability claim, and one that can be very specific to the type of disability, or cancer rather, that you have.
Yeah.
So make sure the doctors put all of that information in there, both from a treatment plan perspective and those symptoms, and make that application. And the hope is that even with that plan and cancer and all of that put in place, that the insurance company should do the right thing and actually approve your claim. And if they don't, then hopefully there's an opportunity to have a further discussion, because the optics don't look good for insurance
No, not at all.
companies who are denying claimants who have cancer.
And to your point, sometimes that when you go along that treatment path, several months in, then you start really feeling lousy. That's when you need to go off. It might be the treatment itself that's causing that.
Exactly. The treatment itself is what could be causing it. And so courts have made clear, look, if you've got the symptoms, regardless of the diagnosis, those symptoms should be sufficient to support a disability claim if your doctors are saying that you're not capable of working as a result of those symptoms.
So based on that, you get the diagnosis. Eventually, maybe because of the treatment, you've been off sick. Number two, some disability policies consider cancer now, you know what's coming, to be a pre-existing condition.
It's so frustrating, this pre-existing condition clause, John. I'm going to get on my soapbox and talk about this, because this is a clause that was conceived of in policies really meant for people to not insurance shop. So think of a scenario where you may have a diagnosis that's pretty serious, like cancer. Perhaps you're not working, but you're thinking, I'm going to need some benefits. I'm going to go find myself a job, get on the benefit plan, and then hope I'll be covered when I need the treatment and so on. Well, these pre-existing clauses were meant to deter that kind of behavior. Well, again, the cynicism that comes from insurance companies, because that behavior is very limited, and yet I see a lot of declines of disability claims based on this pre-existing condition clause. And it's a clause that comes in if your disability has arisen in that first year of coverage under a certain plan. In that first year, the disability insurer will look to see whether or not the claim that you're making now was medically connected to a health issue that you previously had. Typically, it's 3 months before or within a window of time before you initiated your disability claim. What's really important with pre-existing condition clauses is you really do want a lawyer to look at what your policy specifically says. What is the wording of your pre-existing condition clause? Because adjusters often get this one wrong, John, because it is somewhat technical, and it's actually based on the medical information. Not so much, is it cancer, is it something else? It's the medical information that's important. And so perhaps you had a scan 6 months ago, and that scan didn't really tell you much, but there was a symptom that you had at that point in time, but you were not diagnosed for anything until much, much later. That can absolutely happen. Is that a sufficient basis to trigger the pre-existing condition clause? Insurance companies got to tell you yes. I may have a different view of it based on what I look at from your medical information and what your specific policy says. So if you do have a cancer diagnosis and you are proceeding with a disability claim, I want our viewers to know that if your insurance company is resisting this type of claim based on a pre-existing condition clause, it is very important to get proper advice so that you know, is there a basis for me to challenge? Because with most cancer clients that I've had, John, it's not just a one and done. It's not like they are just being treated for the one distinct issue and then they're going to get off claim and get back to work. Ideally, that would work for most people, but the vast majority typically have lingering health issues, and they do need those income benefits to allow them the time that they need to recover and rest and get back, hopefully, to some kind of work setting.
Cancer and long-term disability. Fact number 3 is this: many claims are still denied as insurance companies believe individuals are able to do a sedentary task. Right?
The sedentary tasks. Yes. This is a fallback for disability insurers. You know, any job that you are doing, the fallback for insurers is, well, you know what? You can sit, so you should be absolutely fine. Here's the thing. A lot of these types of disability claims, cancer in particular, typically have secondary health issues that are just as significant. And mental health comes to mind right away. Right away. It's natural to be concerned around recurrence of a cancer condition, having lingering fatigue. Some cancer patients still have neuropathy, which is numbness in the hands and feet. And so no, if you've got lingering numbness, you're not going to be able to sit at a computer and type, right, John, or do these prolonged sedentary type tasks. So the inclination for adjusters is to do what they always do, which is to rely on the few ways that they know or that they have to deny these types of claims. But cancer doesn't fit in this neat box, and certainly not all types of cancers can be treated and adjudicated in the same way because of the lingering aspects of this kind of diagnosis and the treatment. So look, I think that these claims are being denied by insurers because there is that concern that perhaps they're going to have you on claim longer than they wish. And really, optically, it's not great, as I said, for insurance companies to be denying these types of claims. But I got to tell you, if you are denied in a situation like this, I kind of like the optics of it. I do want to be able to advocate for individuals like this because it does not fit within that straight, narrow adjudication beginning to end. And this is really where disability litigation and a legal claim is hugely important.
There's your 3 facts. You want to reach out for more, you can do that anytime. We'll get into a quick break and then go to mydisabilityquestions.com. Yet another website built for you to ask questions with Tamar and her team. We'll do that after the break. That phone number, though, 1-855-821-5900, or email help@disabilityrights.ca. And we'll continue with more of the Disability Law Show. Hang in. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thank you so much for hanging in. A few minutes to go here on the Disability Law Show. Reaching out to Tamar Agopian. Please do anytime have that conversation. Could be for your benefit, maybe a friend, family member, colleague who's dealing with that insurance company. 1-855-821-5900. You can go to help@disabilityrights.ca. That's the email address. And this website, just as handy. It's free. It's anonymous as well. mydisabilityquestions.com. You can read some of the questions there anonymously, or if you want to add your question to the fray, you can do that. Possibly it's been asked before. It'll save you some time. If not, leave it there. Tamar and her team will get to it. mydisabilityquestions.com. This is Craig's turn. Says, my brother was recently denied LTD because the insurance company believes his back issues were work-related. He was working as a mechanic, but his injury developed while doing some work around his home. His doctor and physiotherapist think he may never be able to return to his job. Is he still entitled to benefits?
He is absolutely still entitled to disability benefits, John. I mean, just because Craig's disability, they think it came from work, it came from home, it doesn't really actually matter. The fact remains that his doctors, his physiotherapist and his doctor believe that he may never work in his job again. And that is the starting point for most disability claims. You know, when you apply for long-term disability, I think the thing that gets lost in the foray sometimes is what caused the disability. And that causation analysis, we call it as lawyers, doesn't really matter in disability litigation or disability analysis. What matters is that there are symptoms, there are restrictions and limitations that are supported by the doctor, that the doctor is telling you that you cannot work. If that's the case, then you absolutely should be making your disability claim, regardless of where the actual place or time or why as to what the disability is. Now, of course, when I think about Craig's situation, John, it does come to mind that if it is workplace related, there could be other benefits that are available.
Yep.
Workers' compensation in most of the provinces that we operate in are available as well. It's not necessarily the type of work that we do, but it does work in tandem with these kinds of disability claims because it is another avenue to get treatment support, to get other compensation, income support at times as well. And there will be a coordination of benefits between workers' compensation and long-term disability benefits. But you want to make sure that you're applying for both. Don't just assume, just because your employer is saying it's employment related or someone else is saying it's employment related, doesn't mean that you're not also entitled to long-term disability. So if I'm in Craig's situation, his brother reached out to us and he said, look, on his behalf, I think that he may be entitled to it, then he should put that package together. He can get the package either from his employer or he can download it off one of the websites from the insurance company and put that through, making sure that both the doctor and the physiotherapist is connecting the health issues with his inability to do his occupational duties.
David is up next. Sent an email along, again, help@disabilityrights.ca. Right. Dave says, it took some time for my sister to send the necessary medical records to the insurance company as her treating doctor was away. Her claim was then denied due to insufficient medical information. I don't understand how this is possible. Should we appeal this decision? First of all, no.
No. Let's start with the appeal part of it, John, is that I really do have a hard time in situations where it's insufficient medical that individuals appeal. Now, the appeal process is not something you're going to see in your policy. And in fact, there's no real hard and fast rules around when the appeal has to be submitted or what has to be submitted for that appeal. And it really achieves what insurance companies want you to do, which is to keep in their system, to keep trying again, pretty please, can you get this?
To get that carrot.
To get that carrot. And I don't want to see David, and his sister be frustrated through that process and say, you know what, it's not worth it. We're just going to forget about this and, leave money on the table. That's why the appeal process is so frustrating. And so in situations like this, I would much prefer that David and his sister pursue their rights via a legal claim, with the caveat that if not enough medical information was actually available to the insurance company, and the information actually is different from what was initially provided, that would be the only caveat where I might say, maybe you do want to supply additional information to the insurance company. But I got to think in a situation like this, if the adjuster was too impatient, if they knew that there was more medical information coming and they decided to make a hasty decision to deny the claim on the basis of insufficient medical, I don't suspect that adjuster is going to change their mind if you appeal the claim. It's human nature, John. You're going to get that same adjuster looking at the same information, rendering the same decision time and again. And so I think that what concerns me is that it can be frustrating for individuals in situations like this where the doctor has said that I can't work. Why is it that the insurance company is not accepting for face value that this is enough?
Right.
And they should. And I can tell you, if we're involved, it's going to be a very different conversation with the insurance company about whether or not these disability benefits are payable.
And how about the hastiness? Like the doctor's away, settle down, you get the information, just dial it back a bit.
It is
talk about
hasty,
pressure.
especially since I'm so sympathetic for doctors in the country right now. They are absolutely overwhelmed.
Yeah.
Many of them don't know how to necessarily deal with the time requirements that adjusters arbitrarily put to our doctors to provide information, or even patients who might be saying, look, doc, I need your help. I need this medical information put over to my insurance adjuster to look at my claim and consider it all. And it's simply not a priority necessarily when they've got a room full of patients that they still need to see.
Sense.
And so I don't like this profile whatsoever in terms of the conduct by the adjuster and the insurance company, which is why I would discourage the appeal, even in a context like this. And
with that, we are pretty much done. You want to reach out to Tamar and her team now, you are feel free to do so. In fact, you're encouraged to do so. Phone number is first, 1-855-821-5900 is how you do that. That email address is help@disabilityrights.ca. And of course, mydisabilityquestions.com. You can always ask your questions there as well. Willing to help at any time. Thanks for joining us. Thanks for all your input. And we'll join you next time and see you next time on the Disability Law Show.